2010. I don't know, I'm not sure Mr. Max is yet here with us, but if he's able to join us, I'm sure it is going to be a wonderful time in class with him. Next, we have Mr. Sand Mbakalu. Mr. Sand Mbakalu is an international development expert with over 15 years of experience in implementing projects related to geographical indication, international trade and investments, trade policy, research, policy reforms, market access, monitoring and evaluation, capacity building, market linkages, and value chain. He served as the lead technical consultant for the Africa Intellectual Property and Innovation Project, which is funded by the European Union and played a crucial role in assisting the Nigerian government in establishing a robust framework for protecting and promotion of geographic cow indication. Additionally, he is the chair of the organizing committee for the All Africa Intellectual Property Summit and has led several other development projects in Nigeria and across Africa. Currently, Sand is the executive director of the Africa International Trade and Commerce Research and is pursuing a PhD at the University of Cape Town in South Africa. Next, we have Mr. Folarin Aluko. Mr. Folarin Aluko is a legal practitioner and partner in the firm of Truman Rockwood Solicitors, where he provides advisory and consultancy service to company and a wide range of creators, users, and startups. Folarin is the director of the Intellectual Property Institute of Nigeria. He is the chairman board of trustees of the Intellectual Property Law Association of Nigeria. Folarin is a member board of trustees of Sports Lawyers Association Nigeria, as well as a member of the board of Nigerian Digital Chambers of Commerce. Mr. Aluko is also a board member of the Songwriters Association of Nigeria with a background in ICT hardware and digital forensics. Folarin has led legal teams to champion consequential strategic impact public interest litigation in the IP space since 2012. Folarin is a consulting mediator with commercial intermediates and an ADR firm based in Lagos and Abuja. He's a thought leader in Nigerian innovation, technology, intellectual property, and entertainment space. Next on call, we'll be having Mr. Emmanuel Agerario. Sorry, sir, if I didn't get the pronunciation of your name properly. Mr. Emmanuel is a highly skilled and experienced lawyer at Olisa Bakoba Legal, a leading law firm in Nigeria. He is a key member of the firm Sports Entertainment and Technology SET practice group and the dispute resolution team, serving as the IP team lead. Sorry, just a moment. Let me try and see if I can fully share my screen so that I can engage with you guys more. All right, so just a minute. I'll be back with reading the profile. Let me see if doing that is going to work now. All right, so I was saying Mr. Emmanuel, as the IP team lead, Emmanuel is responsible for providing strategic and advice and representation to clients on a wide range of intellectual property matters, including trademark registration, enforcement and litigation, advising clients on trademark clearance, filing strategies, and representing them in opposition, cancellation, and the infringement proceedings. Copyright protection and enforcement, providing guidance on copyright ownership, registration, and licensing, as well as enforcing copyright against infringement through litigation and other means. Patent prosecution and enforcement, assisting clients with patent drafting, filing, and prosecution, and representing them in patent infringement disputes trade secrets protection, developing and implementing strategy to protect trade secrets and represent clients in trade secrets misappropriation cases, IP licensing and commercialization, that is negotiating and drafting IP licensing agreement, franchising agreements, and other commercial agreements involving intellectual property rights, data protection, and privacy. Emmanuel also supports clients with compliance issue arising under the Nigerian Data Protection Act. Emmanuel's expertise also extends to dispute resolution. He has a vast experience representing clients in commercial litigation, arbitration, and other forms of alternative dispute resolution, with a particular focus on IP-related disputes. He is adept at handling complex legal issues and developing innovative solutions to meet his clients' needs. He's passionate advocate. He's a passionate advocate for the protection of intellectual property rights and is committed to helping his clients achieving their business objectives. Emmanuel holds a master's degree from University of Ibadan and is a member of the Nigerian Bar Association, Intellectual Property Hub, Business Recovery and Insolvency Practitioners of Nigeria Africa IP Centers. He has several publications and has received awards/recognition with respect to his work. Thank you so much, Mr. Emmanuel, for joining. We are happy to have you in class. We have quite a list of mentors that we're expecting in today's session. All right, so please let's settle down and do well. Since this is the first class, let's do well to introduce them very well. Miss Regina Obiechene. Miss Regina is a senior associate and an integral member of the Aluko and Oyebude IP units. As an IP practitioner with over 10 years, practitioner for over 10 years, she represents both local and international clients in a range of IP-related transactions such as trademark, patents, industrial design, copyrights, and related services. She is a member of the International Trademark Association, that is INTA, the Anti-Counterfeit Collaboration, ACC, Nigeria, Intellectual Property Law Association of Nigeria, that is IPLAN, Nigerian Bar Association, and as a result of her work and contribution to knowledge, she has been recognized by managing IP as a rising IP star for many years, and also recognized as an outstanding IP leader in the elite WIPR Leaders Guide, that's 2021-2024. Regina was named a trailblazer by the World Intellectual Property Review 2019-2022 and was shortlisted as 40 under 40 Rising Star by the Esquire Nigeria Legal Award in 2019, that's 2019-2020. Regina is an associate member of the Institute of Chartered Mediator and Conciliators and a member of the Institute of Chartered Secretaries and Administrators. Regina is a regular speaker at workshops and events and also a notable writer who has published many peer reviews articles. Sorry, I think we're missing one mentor. That is Miss Amel Talafoda. I can't seem to lay a hold on her profile right now. So sorry about that. But Miss Amel Talafoda, so sorry I can't access your profile right now, but we will do well to have you speak to us when the time comes. Thank you so much to all our mentors who are currently with us in today's session. I can see a handful of them have joined in for the session. Thank you so much. We really, really appreciate your presence. So like I earlier said, the way the discussion is going to be going, we'll take mentors' presentations first. That is, our mentors will come and give us an introduction into the topic, and we'll be moving from one mentor to the other, and when our mentors are done speaking and sharing their thoughts on the subject matter of today, that's intellectual property for business, we'll be taking presentations from the mentees. So please, group 1 and group 2 presenters, get ready, be set, so that when we call you up immediately, you are ready to take your presentation. And then after that, feedback from the mentors on the presentation, questions and answer, and that will be that for today. So not to waste any further time, I would like to first and foremost give the floor to Ms. Amel Huda Tala to give us her introduction into today's class, and then subsequently we would receive our other mentors. Thank you very much.
Good evening, everyone. Thank you very much for giving the floor. As we have to do the presentation with the others, it's just an introduction. I think that for all the participants who are here today, they know what is the definition of an intellectual property. But for those who don't know, intellectual property is something that we can find everywhere in our daily life. When we eat, when we want to sing, when we want to communicate with people, when we want to learn, when we want even to travel, etc. So we are using intellectual property through different things around us. And those different innovation and creation are things that was think by other people and that were established to resolve specific problem. Intellectual property can take different types of forms. It can be a trademark, it can be a design, it can be an invention that can be protected by a patent, or it can also be a trade secret, to name a few. But intellectual property is something that is very important to manage at the beginning of your project. It's very important to take it into consideration because when you fail to do that, you can fail opportunities. Last week, for example, I went to an exhibition where innovators were presented a new product into the market, a Cameroonian one. And the key of this product was a software that was somehow eligible to patent because it is not all the software that are eligible for patent protection. And we had a discussion with them after the presentation, and they were really sad to understand that when you have already published something, it is no more eligible to patent protection. So you see that now we are obliged to move to other types of intellectual property right to protect this innovation. But it is possible that those innovators should have more opportunities if it was possible to protect it through patent. For young innovators, what I can say this evening is that you have to always find a way to protect your intellectual property. And your first steps is to have a basic knowledge on intellectual property as you are doing this evening. Make sure that you have a basic understanding so that at any stage of the development of your product, you should be able either to identify the different IP rights, but to know how to prevent some specific risk into your environment, maybe with your collaborators, maybe before discussing with investors, etc. It's very, very important to have this background on intellectual property. It's also important to always take in consideration contract. Agreement is something that is somehow live apart when it's come to business, especially with SMEs. But agreement is the laws that help people to manage their business. So it's always good to have an agreement so that people can clearly define what are the rights of each parties and the others one. I will stop there for the time and leave the floor to the other expert. Thank you very much.
All right, thank you so much, Mrs. Amel, for that wonderful introductory session, or just that introductory discussion into intellectual property, and just showing just how important it is to business. So thank you so much, Ma. We really appreciate your insights. I'm sure that as the conversation goes on, we'll get to hear more from you. Share your thoughts based in regards to the presentation and other aspects of intellectual property that you feel would be important for us to know. So moving on to our other mentors. Mr. Emmanuel, are you with us?
Hello, can you hear me?
Yes, we
Yes, sir,
can.
we can.
Okay. If you can hear or if you can see me. Okay.
So your slide went off, but we were seeing your screen, sir.
Oh. So I don't know if you can share from your end. I'm experiencing a glitch. I'm trying to put it up again. I know I initially shared the slide.
All right, sir, we'll try
I'll just
to
quickly
do that.
speak to it. Okay. Okay, so good evening, everyone. I'll just speak to the slides so as not to take much of our time. The slide will be shared with each and every one of the mentees. It's a pleasure to once again talk on this very important topic that I feel everyone should take very important if you're into business or if you intend to do business or if you're working in a company or if you intend to create something, produce something, and you intend people to buy whatever you're protecting. So when we talk about IP for business, one of the things that comes to mind for me is protecting value, securing growth, and preventing loss. And the reason why I say that, I will say that in a scenario, and maybe that will help us to appreciate the reason for this topic. So for most companies, your most valuable assets with respect to your business may be the one you cannot even see. And that's what IP is. It's one of the most valuable assets for business for which people could and cannot really see. Please, the next slide. Thank you. Okay, thank you. So I asked a simple question with respect to this particular slide, and that question is, if someone copies your brand tomorrow, imagine that you have a brand, what happens? If your developer lives with your source code, what happens? If your distributor register your trademark in another country, what happens? We have had a lot of issues with respect to Very Dark Man as it relates to trademark. But these are important scenarios and questions that comes up every day. You see often a time someone is saying, oh, someone else is using my brand name. Someone else is using my business name. Oh, with respect to someone whose picture, because just this afternoon, someone in the office said something that was very important and with respect to a specific client. And what happened? He said, oh, I got someone to sketch a design for me. And after which, I contacted someone who is a tailor that brought the design to life. Now, the person who sketched the design gave it to a person that paid for that specific service. The tailor brought the design to life, and the tailor posted on their webpage with respect to the dress that she has brought to life. And after which she commercialized, and a lot of persons are reaching out to the tailor, I want to make this, I love it, and all of that. But someone sketched it. And we heard that the person who sketched subsequently had to make some comment, and now they are currently in court with respect to, oh, it's my IP, you don't have the right to use my IP, and all of that. So that's I'm just trying to paint the scenario with respect to what we see every now and then. With respect to what we see. So what I really want us to do, I will just give a quick poll. Which of these is intellectual property? Your company logo, your business name, your software code, your product formula, your social media content, then F, all of the above. You can please on the chat box just indicate which of these do you feel is intellectual property. Is it a company logo that you see? Is it a business name that you equally see? Is it the software code that sometimes you may not see? However, there are codes that enable the software to work properly. Or your product formula, for example, Coca-Cola, that enables Coca-Cola to have stayed in existence for this long. Or your social media content, for which we read constantly on social media page. Which of these is intellectual property? You might want to answer on the chat box. Okay. So I will just assume that we answer that with respect to hello, sorry, the next slide. Can go to the next slide. I was speaking to the next slide. Yes. So which of these do you feel is intellectual property? That was what I was just speaking on. Just to stay our mind. Now, you can please answer on the chat box. For me, all of the above is intellectual property. So the next question that I want to ask is, how many of you have formally protected at least one of these? The truth is, whether you like it or not, someone here might just be a content creator. Someone here might just have developed a unique logo or has a company that has a logo that is unique and peculiar to them. That could have been trademarked. Someone could have a business name or maybe a movie character or a movie content that you equally want to protect, or maybe a product formula that you think is unique with respect to that particular product that you could equally protect. Those are IP, and all of those form part of your intellectual property. I will not, the next page, please. The next page. Yes. So I will not speak to this because I believe that a lot of us should already know what IP is. So with respect to IP, we have different types of intellectual property. We have the trademark, the copyright, the patent, and all of those. So if it's important that we understand these different categories of IP. You can go to the next. So I will not speak much on that. The next slide, please. Now, what IP is a business asset, not just its theory. Now, from global perspective, you understand that over 90% of S&P 500 companies' value is now in intangible assets, their brands, their data, their IP. For example, if you see what Netflix says, it's content. That's IP. People watch movies every now and then. The character, the music that you see in those content, in those movies, even down to the scripts, down to the name of the movies, those are IP, and that's selling. It's selling heavily. So that's intellectual properties. Now, companies like Apple and Microsoft corporations derive enormous value from IP portfolios. You see a lot of these people, even Coca-Cola that you see today, down to the bottle, down to the name, down to the content, even the shape of the bottle, they are all heavily protected by IP. Down to even your sports. When you talk about football clubs, the reason for which football is thriving today is because it is heavy on IP. The player's JC, the player's name, even when they want to do a particular promotions and all of that, license to do that. That's IP. And that's how they are heavily making money with respect to that. So the key lessons that I really want us to take with respect to IP is IP valuation, investors' confidence, and scalability. So with respect to your business scaling in the 21st century, is for people to want to really invest in your business. One of the key things that they are buying is not just your products. What they are really investing in and what they want to really get from you is the IP. If I want to invest money in a company today and I'm doing my due diligence, one of the key things that I want to really understand and know for certain is whether or not you have the intellectual property with respect to your business. Because that's really what you're selling to me. It might seem intangible, but that's what you're really giving to me. If you don't have the IP, then indeed you don't own the business. A man that has the IP can control 99% with respect to the income that comes to that particular business. If you look at Mike Jackson today, with respect to his songs, with respect to a lot of things that he did, he made more money at his death with respect to intellect because he was able to, most of his song were heavy on IP and all of that, was able to make more money at his own death, because a lot of persons were playing his songs, a lot of persons were wanting to synchronize those songs, and a lot was heavy on IP, that his own estates had to cash out with respect to those songs, the catalogs and all that. People were pumping heavy money with respect to his work. So intellectual property is what made it possible that even years after those songs were released, it could still generate that amount of money. Now, I will give a business scenario. And the business scenario is this. Please, the next page. A fashion brand builds strong Instagram presence. No trademark registration. Just one of what these Gen Zs went online. It's a strong brand Instagram presence, no trademark registration. A third party registers the name at the registry. Now, the result is this. You're getting a cease and desist letter, and someone is writing to Instagram and saying, take that notice that this name belongs to me. But you've built a brand identity over time. Maybe you've been tweeting for the past 2-3 years, but you've not even trademarked that name. And the results likely will be rebranding costs, lose of goodwill, litigation expenses, because you want to say, oh, I've always been using this name, I was first in time. You want to go to court to say, oh, that is bad faith trademarking and all of that. And there's market confusion as to who really is this. And so a lot of your customers might even be confused, that genuinely want to buy your product, that genuinely want to reach out to you, that genuinely want to invest. But because there's another name that is confusing, they will be reaching out to the wrong person, and the wrong person is getting all of those business and contract because of the brand confusion. So there's market confusion, and you're losing money, losing resources, you're losing goodwill. Just because of a simple thing. There's no IP registration with respect to what you've been doing. So it's important that you protect your intellectual property. So IP for business truly is the value that you give to your business. And it's one of the most intangible value, most valuable assets that any business could really have. Now, you can quickly go to IP and investment. Please, the next slide. The next slide. I will just quickly go past all of this. The next slide, please. The other slide. The other slide. The next one. So the reason why I passed all of those slides, it was just going deep into the different categories of IP, copyright, the trademark, and specifics. So I feel that ordinarily we should have the foundational ideas with respect to all of those different categories of IP. Now, IP and investments. Now, an investors, like I was saying this earlier, one thing that an investor will ask, who owns the IP? So if you have a business and indeed you want people to invest in your business, one of the key things that an investor wants to ask is, who owns the intellectual property rights with respect to your business? Another thing that they equally want to ask is your IP registered? Because some persons, they will say, oh, to understand, this is content, it's a book, and because it's a book, IP automatically subsists with respect to the book. I agree. But registration with the Nigeria Copyright Commission gives a second layer level of protection with respect to your work, and helps with respect to, oh, when they're asking us to first in time, oh, I registered the work in so and so time, this is my evidence of registration. And for anyone that cares to verify, you just go to the simple depository of the Nigeria Copyright Commission to conduct a search, and it pops out and say, oh, this work was registered, it's owned by so and so person, and all of that. So there's a catalog for that makes it easy with respect to when there is disputes. Now, is there risks of disputes? A lot of persons equally want to ask, okay, you own the IP, but is this name confusing? In what category, if it's a trademark, did you register this particular work? Is it in the specific line of business that you're doing, or you trademark this particular, your trademark class is in a separate class that has no connection with respect to your business? And the person is wondering, there's no correlation. you're trademarking in a different category. We all have had, with respect to the very dark man scenario. And so it's important. Is there risks of dispute? Are there licensing agreements? You know, often at times, sometimes you might not be the one that have the intellectual property. For example, for those persons that produce movies, someone might be the writer, and another person might equally be the producer of the movie. Now, the producer might say, oh, I'm engaging you to write and transfer your intellectual property rights with respect to this particular movie. For others, there might be a licensing agreement that says, oh, you have the right to use this particular intellectual property for your business. And that's what you see a lot of fintech agencies, they do now. For some of them, they don't have the licenses. For some of them, because of the money that are involved, could not get all of it. And what they do is they get licenses for those persons that are already registered, that has the certificate, that has the IP with respect to it, and they ride on that intellectual property right and say, oh, let me go into partnership with you. I want to obtain your license to be able to use this for a period of 5 years, for a period of 1 year, for a period of 2 years. You see a lot of franchising also. If you see most of the top fuel stations, for example, you see NNPC in those stations, and you say, oh, this is NNPC. It's not really NNPC per se, but it's because someone has given license or franchise and say, oh, this particular franchise you can use for this particular period of time, and there's a level and standard that is given. So as a business owner, you might not be able to say, oh, I want to register this. Oh, I love what's happening in South Africa with respect to a particular hotel, maybe Wellington Hotel or Transcom and all of that. And you say, oh, I could get the franchise, I could get a license to use and equally build that similar brand in Nigeria. And as such, you are leveraging on the IP for your business. Now, without clean intellectual property rights with respect to what you do, your D's might be stalled. Valuation with respect to your business will drop. Due diligence will fail. Now, if I'm going to do a due diligence for a business that does not have proper IP registration, one of the key things that I want to raise as a red flag is that, oh, I don't think they own the IP. And that becomes an issue with respect to your business. So it's very important that we understand some of these things. I think I will stop here so that other mentors can also speak to the topic. Thank you very much. So my slide can be shared, then we can also, as conversation goes on, we can speak more on it.
All right. Thank you so much, Mr. Emmanuel, for sharing your thoughts. We really, really do appreciate everything that you have taken our time to explain. Thank you so much, sir. We still have, I think, some mentors on the call that have already joined in, right? I think we'll be going next with Mr. Sand Umbakalu. Thank you so much, sir, for joining us. We are happy to have you on the call. Sorry, like I said, I'm experiencing some network challenges, so my video may be scarce, but I will try as much as possible to still try to turn on my video when I can. So, Mr. Sand, you're welcome, sir. Thank you so much for joining us in today's session. We would just like to get your thoughts also on the topic for today, intellectual property for business.
All right, so thank you very much. I want to say good evening to everyone, assuming that we are all within the same time zone. I also want to commend Juliana and the leadership of GIPCC, the platform, for being consistent over the years in ensuring that the gospel of intellectual property is preached to our generation, not just to our generation, but raising men and women that believe in the cause to see intellectual property from a different perspective. Even though from the policy angle, we are still dragging, but who says that one person from the people that have gone through this program will not be the registrar or the president of a country in Africa that will be able to see that this issue of intellectual property is demystified to the extent that is seen as a strong enabler of sustainable business, just as it was done in Japan. Anyone that buys anything from Japan knows that you are buying quality, and for that reason, it can be trusted. We can never, I say this word with all sense of consciousness, have a sustainable business today without understanding and putting intellectual property to the fore. And I must make this confession at this time. And I hold this view previously because I took into consideration the situation in my dear country, Nigeria. And I said, that view, I made this confession because I've changed it, is that you don't need to invest in your intellectual property when you're starting a business because you don't even know if it will be successful, because it takes time to go through this process of intellectual property registration, basic ones, trademark. The law says 6 months it has to go through. We just finished a study getting the public perception of intellectual property in Nigeria, how it implies, we spoke to stakeholders. We come to realize that the law, 1965 law, still stands. Until change, it will not. However, that view of saying a business should not go ahead and register intellectual property has changed, because I've come to realize that as you are registering your CAC, you are drawing out that certificate out. The next thing you should put in for is your brand name, in anticipation that you go blow. You go blow in the sense that if you don't put that in, and the time start, and documentation, because it comes to documentation as well as being consistent with your design, color, your logo, and rest of it. If this is a practical term, I'm not coming here to talk about, of course, as I've narrated, I'm in trade. What concerns me is how do we transform some things to make money, not to make money in the sense that it will undermine the economy, undermine people, undermine the environment, but at the same time, it can go side by side. That's why I call myself, and I believe strongly on the Afro-capitalism. So what I'm saying is that I've changed. I'm a change man, saying don't register your IP when you start, but register it after. But I say now, as you are filing for CAC, you also start filing, because by that time you should know your logo, your design, the pattern you are following, you are using, and go with it. Even if it's going to take 4 years to come out, you know that you started that process. Ladies and gentlemen, IP is not a legal concept. IP is not an abstract. Reason why you see Dangote, you cannot even go and register Dangote as we speak now, is because IP is the underlying factor. MTN has demonstrated that intellectual property is often not just about the foundation. Now is about the competitive edge it gives to your business. It generates revenue for you. You can go, if you do it, you are getting yourself into trouble. As a matter of fact, if you go to CAC now, just say want to register Dangote, they will deny you because it's a known brand. You understand? So it is that intellectual property that they are scared of. So, but Africa has started seeing it. Africa has started seeing this light. We are still young in this game of intellectual property, because years before now, I personally didn't know much about intellectual. My gateway into intellectual property was geographical indication. When I saw the importance of geographical indication on how it creates wealth in the local area, how it maintains generational wealth, I said, wow, and what are we doing about it? Apparently, we're doing nothing. And I keep on single-handedly, I must say, with humility though, because at the end of the day, we're able to raise team that say, okay, let's go for this geographical indication stuff. And we start pushing, and that opened me up to other aspects of international pattern. And I realized that Africa itself is playing cash up, because the concept itself is not well understood. They see it as something. How do you go about it? So that's why our laws don't speak to it. That's why we are not mainstreaming IP. So because IP is transformational, a number of companies have started keying into it across the continent. So it's supporting now scaling of businesses, supporting now attracting international investment, it's supporting now people wanting to address the issue of weak protection. It's now addressing this issue of awareness, and as well as addressing the issue of delay registration of intellectual property, which of course, delay registration of intellectual property, as former colleague have said, It's missed opportunity, missed revenue, and all manner of stuff. Sometimes it might even be litigation because I don't want to dabble into all the social media stuff. Someone saying he's racing 43 right in Nigeria. When I'm just saying you can't even race that one without 6 months, you just say filing. Is that not madness? But that is not a joke. These are people cashing cloud. I will not encourage anyone to follow that stuff. It's waste of time. But the most important part I'm going to bring out now is that, you see, how many of us know when FruitaWave started? FruitaWave started in 2016 or thereabout, but it's $1 billion firm. I know there's a lot of friends and colleagues that are mentors in the room today, so I will not want to speak and take a lot of time, but I want us to look at FruitaWave. FruitaWave is and FruitaWave, MoneyPoint, OPay. These are new generation fintech companies. Look at their history. They are less than 2016, maybe less than 15 years maximum, all this, but they are multi-billion. The foundation is that they have intellectual property. If they tell you that everything FruitaWave have, when FruitaWave started, they trademark, they have trade secret, algorithm, they protect it, software, copyright, they combine everything. And that's what gives them an edge. So when they are coming to negotiate, they bring this in. I have this protected, I have that protected, I have that. So even you negotiating with them, know that you can't invest into them or circumvent when they bring out NDC, non-disclosure and non-circumvention agreement, you sign up and they disclose everything for you. If you go ahead and say you want to copy them, you get into trouble. They're not doing that to say that they are scared away, but they're doing that because they have realized there is a model for growth. In PASA, I can go on and on and mention African brand that have leveraged IP to become what it is. Nollywood has not done fantastically well. There is a school of thought that said Nollywood piracy was what promoted it. Some people say no, they will have gotten more money, but it can be anyone. This is a discussion for that thing. But for IP and business, is the same. IP, intellectual property, and your business idea, even you yourself, but you have to bring it into the consciousness of the African context. When we say Africanizing IP, I'm one of those people that believe strongly on that and advocate for it. Africanizing IP, it means that you don't just build IP to deny your people opportunities for growth or to innovate just because you want to amass wealth for yourself. We collectively grow together, right? We collectively grow together in IP in Africa. That is the mindset. So everything IP, everything I see from a lenses of our culture of sharing, but at the same time we progress together. At the same time, we don't just do that because we're not stupid about it as well. We're not stupid about it that we create an idea and people just take it and just go. Bottom line, because I don't want to waste a lot of time, I don't want to take time of a lot of senior colleagues that are in the room that also want to share their thoughts. I have a lot to talk about these things. This is one of the things that over time I've come to realize how important, how transformative it can be, that I throw myself into it and say every year people will gather across Africa to speak about IP. And it doesn't matter, over time, we start showcasing how you can use IP to scale and to keep generational assets for your family. In Africa, there's a generational cost, generational abiku or banje, generational. There is nothing as such. It's because we've not created value from beginning. Money making is creation of the mind. But if you don't start earlier, you start thinking about how to create money or protect your asset when you are 50 something. How many years more do you need to live? And you then leave one bucket or one spoon for your children yet unborn. You then realize that they realize they don't have anything to build upon. So IP for me is transformational, is protecting your knowledge, value, asset, scaling your business. I leave it at that, and I just want to enjoy. By the way, I went through your presentation, fantastic presentation, the two groups, but you must move away from the theoretical part, definition, all this stuff. Move away from it. There are everyday cases. Sorosoke just happened some years back, 3 years ago. Who has taken over that? People started, a woman can never restart Sorosoke. And who has taken over? Who owns it? Because our government doesn't understand this, and nobody, even the bar associations and NASIMA and their chambers, don't understand these things. They don't. And I just keep on looking at money on the street flying everywhere. Someone says one wish anyway. Look at it, we don't have power. My office, we don't have power. It's IP, small IP thing will turn everything around. But we're not investing in thinking. We're not investing in our ability to create solutions that are innovative to solve our problem in the world, in Nigeria. We keep on doing some things repeatedly, and we blame someone. We keep on making it theoretical. When it comes to even taking the heavy lifting, we don't do it. Ladies and gentlemen, fantastic. I'm happy to be in the midst. I'm happy to learn, and I'm also happy to contribute as we move on. But IP and business, they're twins. You can't separate them. Thank you very much. Over to you, Mr. Moderator.
All right. Thank you so much, Mr. Sand, for such a very, very wonderful highlight to intellectual property for business and its importance and the role it plays and how it can be monetized to, to make profits, which obviously should be the sole purpose for every business, which is to make profits and do it in an ethical way and cover up for any loopholes that may want to in that sense spoil business for them. Right. So thank you so much, Mr. Sand, for sharing your thoughts. We have one more mentor that is currently on the call. That is Mr. Max Ikombe. I can see you on the call. Thank you so much, sir, Mr. Max, for joining. We will also want to hear from you, sir, also in like 10 to 20 minutes. Share your thoughts. And then after that, we would then start heading to the mentees presentation. So mentees, please, while Mr. Max is sharing his thoughts with us, let's get ready to make presentations in class. So Mr. Max, over to you. If you are ready for us, we are ready for you, sir.
Okay, thank you, Dennis. Confirm you can hear me. I'm sorry, I apologize. I can't put my video on. My location is not appropriate, and my internet can be a little bit slow. But confirm you can hear me, Dennis.
Yes, sir. I can hear you loud and clear.
Okay, thanks so much, Dennis, and Happy New Year to you and all the team at GIPSY. Of course, I would always commend the great work. Just like let me join my brother Sand to commend the work that GIPSY is doing, spreading this gospel of IP to a new generation of practitioners. I think it's really commendable, the consistency with which GIPSY has done this over the years. And let me also thank all the other mentors who have gone before me, Amel, Mr. Emmanuel, and of course, Mr. Sand as well. I'll just take a line from Amel. I'll try and keep my comments very brief because I'm really interested in the presentation of the mentees. I also, like Mr. Sand, had gone through the presentations, and I think I have a thing or two to learn. So I would also take the seat of a mentee while the groups make their presentation. But I wanted to just draw attention to something that Emmanuel touched briefly in his presentation, which is about the fact that IP, can be a strategic business strategy. So there are certain industries, for instance, where without IP, those industries would not exist, or if they exist, they will not exist in the form in which we currently see them. That means they will be a lot smaller, a lot less profitable or revenue generating than they are currently with IP. One of those industries, for instance, is the sports industry. Now, how do you know the impact of IP in sports? Ask yourself a simple question. Historically, look back at, say, football clubs, for instance. Let's use, for instance, Manchester United. Old Trafford, their stadium has been there, maybe since the early 1900s, maybe 1930 or thereabouts was when that stadium was built. The stadium, of course, has been expanded, and its current seating capacity has been consistent for a long period of years. So, but think about it. What has changed the revenue base of that club over the years? Because the primary way a football club makes money is by selling tickets on match day. But if the stadium is capped at 66,000, it means once they have sold 66,000 tickets, they can't make any more money. And if the capacity of that stadium has been 66,000 for at least the past 30 years, then how come the revenue profile of the club has changed so dramatically within that same period? The answer is staring you in the face, and it's very simple: broadcasting. While only 66,000 people can cram into Old Trafford to watch a football match, over 100 million, maybe even up to 1 billion, can watch the same football game because it is broadcast online. It's broadcast, to the homes of people. So the question is, what protects or what makes broadcast possible? It is intellectual property. So when we get into the meat of intellectual property in copyright, one of the rights protected is broadcast right, which simply means that no one else is permitted to come to Old Trafford, film the football match, and broadcast or share it to people. So to do that, you need to enter into an agreement with maybe the English Premier League or the UEFA committee managing the particular competition and the football club as well. So you can see that the football club makes some revenue from granting the permission, the license to film and broadcast the football match. And that makes them a lot more money than selling physical tickets. So you can see that without IP law, if copyright law and broadcast right as a strand of protection in copyright law does not exist, you'd see that sports would not be what it is. I mean, I just watched the Winter Olympics in Italy, and it's the same principle. I mean, I sat in the comfort of my home, watched the highlights on YouTube and all. So you can imagine if that were not the case, how much it would cost me to buy, to have to buy a ticket and fly all the way to Italy. So it tells you how IP can expand dramatically the revenue profile of a particular human engagement. So many other industries, same principles apply to. In the pharmaceutical industry, for instance, it's a very capital-intensive industry. So without the protection that patent law, for instance, grants, without the protection that patent law grants, for instance, you can imagine whether investors, banks will be willing to fund the huge revenue and development, the R&D budget of pharmaceutical companies. But they are able to fund it because they know that the moment that R&D turns up an innovative new drug, patent right is gotten over that drug, and that they have a 20-year monopoly within which only that pharmaceutical company will be allowed to put that drug in the market. And of course, because I mean, if you are the only one putting a particular drug on the market, it means you can command premium price for it. So within that 20-year period where you have your patent monopoly, you can make your money back, pay off, of course, the banks and the other the banks and the other financiers who funded the research and development. So you can see that without IP law, specifically patents, for instance, the pharmaceutical, maybe also trade secrets to an extent, the pharmaceutical industry would likely not exist or be able to operate at the level it currently operates at. So there are so many other industries we can apply the same thing to. So you can see that IP, beyond being just a legal concept, also is a financial concept. It is also a risk management concept, because even in, for instance, fintech, a lot of venture capitalists and equity funders will not put money into your fintech except they can see that you have something unique. Typically, if you have strong IP, that becomes one of the collaterals or the assurance they have for putting their money in, knowing fully well that even if things go bad and they have to wind up their investment in your fintech, likely those IP assets you already have are some of the things that can be sold and ensure that they get a return on their investment. So with this, I hope you can see that IP in business is really a huge deal. IP in business is not just about protection alone. It's about making revenue. It's about risk management. It's about, your revenue profile. It's about so many other things, much more than just the legal concept of giving you that monopoly or protecting you from others appropriating your intellectual assets. So, I look forward to your presentations and we'll take the discussion deeper as we go along. So thank you so much, Dennis, and back to you.
All right, thank you so much, Mr. Max Ikombe. All right, our mentors have been very, very dutiful, right, in just sharing their thoughts, and even in a very short period of time, right. I'm sure we have been able to grasp some of the highlights from everything that they have said in regards to IP and how important it is in protecting businesses and making sure that businesses maximize profits from taking advantage of IP, from as simple as registering your name, your company's name, your ideas. Just the registration of it can just protect you from unnecessary loss and some of the issues that comes with having people stealing your ideas. So IP gives you that edge, and our mentors have done so well to share their perspective on how best to take advantage of IP for business. So based off of what we gave the mentees, we would like to hear from you. That's the mentees. Share your thoughts through your presentation. Right. So the group presenter for group one, if you're on call, kindly go ahead, share your slides and start your presentation. You have 10 minutes for your presentation. And then after presentations are done, we'll go back to the mentors to get feedback and any further things that they would like to share in regards to the topic for today. The presenter for group one, are you with us? Goodness is supposed to be our presenter for today. Goodness, if Goodness is not available, is there any backup
Good,
presenter?
I'm available. I'm trying to share the file.
Oh, okay. If you're having issues, let me see if I can do that for you.
Hi, sir. This is not the group one's topic.
All right, so can you see my screen now?
Yes, I can see the screen.
Okay.
Okay, so good everyone. My name is Akubeze Goodness. I am the presenter for the group one, and our topic, I will be talking on intellectual property for businesses. Please, can you move on to the next slide? Okay, so it's very important for us to know what IP is before we can know what IP is for the business aspect. So IP is something I normally refer to as a brainchild. It is the creation of the mind. This is something conceived of the mind. And there are other aspects, different categories of IP, such as patent, trademark, copyright, trade secrets. But for the purpose of the business aspect, we'll be talking a little on patent, trademark, mostly in this presentation. So intellectual property includes invention, brand names, and creative work. Now, it is a very valuable asset for the business. This is because it gives the business its brand identity, its uniqueness, and makes it different from other brands out there. So it provides a legal protection and commercial advantage over your competitors. And in today's business environment, IP is more than just a concept. It is like a strategic asset. Businesses use IP to protect their innovation, build their brand, their recognition, and generate income. This is like the major focus of IP for this business sector, because generating income is something anyone going into business would want to achieve. So please, can we move on to the next slide? So what is patent? So like patent is like a legal protection granted to inventor of a new invention by a legal authority of a particular jurisdiction. This is a legal protection that grants the inventor the right over that particular invention. And one of the major requirements for any before you get patented is that it must be a new and unique invention that has not been made known to the public. And this when awarded a patent, it gives you exclusive rights as the inventor, gives you the recognition to be known that it was your creative ideas, like it was made by you. And it prevents others from using it, selling it, or commercializing that particular invention. So patent normally lasts 20 years, depending on the jurisdiction. Next slide. So another aspect of IP for business is the trademark. Now, this is like what I normally refer to as a brand identifier, because this is what's normally used to identify a particular brand. It is that uniqueness, that thing that makes a brand different from others. It could be a sign, a name, a logo, or even a symbol identifying that this particular goods or services comes from this particular entity. Trademark differentiates a particular brand from other brands. It gives you a uniqueness that with over time, it creates a kind of bond with your loyal customers that they can be able to identify that such a product is coming from you just from seeing the logo. And it differentiates your business from the competitors. Just like we have Apple products, whenever you see that logo of the half-beaten apple, we can be able to infer that this product is coming from IP Inc. because the brand, the trademark is there. You can see the logo. And trademark can be renewed indefinitely as long as you keep protecting, like you keep renewing your registration. It can be protected indefinitely. So when you have like a particular trademark of a product, it builds your brand recognition that your customers can trust, and they don't need someone to tell them, okay, this brand, this is coming from Apple. Once they see the logo, they can be able to know that this is coming from the brand I love. That this helps loyal customers get the value of what they are paying for. Like you're getting an Apple product, you see the logo, yes, this is an Apple product, and you don't pay for something else. So it builds that trust with you and your business and your loyal customers. Next slide. So now when we talk about registering patents, I would always advise that you cannot get a legal protection unless you follow the procedure that has been laid down by that jurisdiction, like that governing body. So for you to get patented, you need to register, because registering gives you a legal backing. Otherwise, without registering your patent, you cannot get a legal protection. And I think in this presentation, we'll consider a patent that was lost due to not filing early. And so why it is important to register a patent is that it provide exclusive legal a right to the inventor. Like, this gives you the right as the owner. You gain the right to do as you wish with your invention, so long it's not violating or criminalizing anything. Like, it gives you the right to sell, to franchise, to license, even commercially monetize that particular invention. It prevents competitors from copying or selling your invention. Now, let's say you invent this pen now, and you went on to patent it. So it protects you, give it the legal protection that no other company or brand can make the same pen with the same functionality and appearance as the one you have patented, because the government has conferred on you the legal rights to be protected, to be known as the owner of that particular product. Now, another reason why you should register a patent is that encourage innovation within the company. It attracts investors for potential profits. Okay, let's say you've patented a product, yes, and the product is something that can be profitable. Now, investors would not want to invest on something that they know will crash within the next few years or so. They want to invest on something that will generate income for them over time. So when you have patented something that has been found worthy of being patented, investors would want to invest in your particular invention so that they also can earn from your creation. And it grants you a competitive edge and industry prestige. Like I said, you've created this product, the whole world knows it was made by you. You have the right to use the product, you can sell it, you can license it, you can franchise, use that particular invention as you wish. Next slide. So if you looking at some patent cases, the ones that were successful, and like I said, the ones that was not successful because they did not register. The Qualcomm patented a wireless technology which we know now as the 4G, 5G. Now, this particular patent has secured exclusive rights to invention. They have generated over 1.3 billion in quarterly revenue. Now, this is because that particular person invented the invention, went on to register and patent that particular creation, and was awarded the patent rights. So now they can be able to commercialize that particular product, that particular invention. We'll also look at the failed patent case of Douglas Engelbart, who invented the first computer mouse in 1960, but his patent was not fully secured early, so he lost the potentials of revenue opportunity. This is because he did not get the patent protection, so he cannot commercialize. The law would always want to protect something that they have recognized as something that has a legal backing. And in this case, he did not patent that particular invention, so he lost the commercial value for that particular invention. Next slide. So moving on to trademark, we've known that trademark can be like a sign, a slogan, a symbol. Now, why it is important to register a trademark is that it secures an exclusive legal ownership over that brand, logo, and slogan. Now you've gotten like a trademark that fits your brand, and you went on to register. Now this gives you an exclusive legal ownership. You get to use this product for your brand without anybody interfering. The law would protect you from other persons who would try to steal that particular product in order to pass off from you. Now, it prevents competitors from copying and confusing your consumer. Let's say as Apple, that logo now has been trademarked. It will stop another company from using that particular symbol for their brand identity. This is because it has now a legal backing that is the legal ownership of that particular logo. No other brand can use it. Now it has built a kind of trust and loyalty over time with its customers. Like, just seeing the logo alone, you can like say, this is the company I love to buy from. This is the brand I love, without anybody telling you that this is actually coming from Apple, this is coming from this particular brand, because you have seen that particular identifier. Because trademark is like a source identifier. You get to identify where this product is coming from just from seeing it. Now, also, another reason to register a trademark is that it provides legal basis to fight infringement and counterfeiting. You've trademarked a particular sign or logo. It gives you that legal backing to sue and enforce your rights if someone else tries to copy that particular trademark in order to pass off your customers, confusing them that this product is actually coming from them. Because a lot of time when a company is actually doing good, there will be competitors who would want to like pass off and try to earn from someone else's hard work. So now the law has given you the right to enforce your right to fight against any infringement on your trademark. Now it distinguishes your products or services from competitors. Trademark gives you a sense of uniqueness. It differentiates you from the crowd. Like it is a brand identifier. It identifies that this brand is coming from this particular brand. Like when a customer who has used such products, loves such products, and wishes to continue with that product, and knows that this is how the trademark looks, this is the word. So when it builds that loyalty with your customers, it distinguishes you from other brands. That is the uniqueness I'm talking about. Sorry, next slide. I'll also be looking at trademark cases, the ones that failed and the one that was successful. A very popular trademark we all know is the Coca-Cola. This Coca-Cola, has trademarked the logo, the bottles, and the color schemes. This has prevented any other soda company from copying it. Yeah, there is other soda company like RC Cola, but Coca-Cola has its unique presence. Like, the trademark has been built and the recognition has gone beyond just one of the startup. It has gained a lot of presence that has created a recognition among loyal customers who has trusted that particular trademark to come from a very good source. And over time, they have generated over 320 million naira annually. Now, the trademark has a strong brand and identity, and this has resulted to a massive distribution and consumer loyalty because they have trademarked that particular logo, that particular bottle and color scheme. Just looking at a Coca-Cola bottle, you can tell this is coming from a Coca-Cola. It differentiates it from RC Cola, from Biggie Cola, because it has gained that loyalty within customers that whenever I see this particular sign, this particular logo, this is the brand I want to go. Also, another unregistered trademark revenue loss is the case of Sabinus and Wancom Nigeria PLC. I think it was around 2022. There was like a saga between Sabinus suing Picnic for using his slogan "something huge." Now that particular suit failed because the trademark application was still pending. It was not been actually trademarked, so it cannot be enforced in court because the law would always want to enforce something that has been registered, something that has been recognized to it. So that particular trademark lost that case. The legal ownership was not fully secured, and it lost revenue, and it lost revenue of obtaining damages from Picnic because the trademark has not been registered. It has not been recognized by law as a brand identifier. Next trademark, sir. Next slide. Okay, so moving on to IP licensing. So the licensing is a contractual agreement allowing a person known as the licensor to grant a right to another person known as the licensee. So now, the original owner granting that individual that wishes to use that intellectual property to gain from it. So it grants them the right to use, to distribute, and exploit that particular IP in return for a money consideration called payment or loyalty, depending on how it was drafted in the contract of how payment should be. Now, IP licensing creates a sustainable revenue model where the owner still retains full ownership while still earning from licensing the product to another person. Now, licensing does not mean that you are giving up your rights fully. You are not selling the product, the IP, I mean, to that particular licensee. You are only granting them the right to make use of the product, the right to distribute, and the right to commercially exploit that product or the invention. Now, IP licensing is governed by Copyright Act of 2022, the Trademark Act, the Patent and Design Act. Now, this is because the law has recognized that there is a thing known as IP licensing, whereby a company or a brand can grant another person or another entity the right to commercially exploit that invention while still retaining ownership for for a shared revenue or royalties actually. Next slide, please. And the next subtopic will be IP, intellectual property franchising. So franchising is something I normally call like a specialized high level form of licensing. Franchising allows a business or a particular brand to grant another party the right to operate using that particular intellectual properties brand identity, the business model, the technical know-how, just giving out like the full run on how the business is being run. You are giving it to someone, not giving up your rights, but license in it for them to use your model to run the business in another location. It helps the business expand quickly without directly managing the new location. This is because you are granting that new entity, that interested franchisee, the right to run the business. Let's say KFC. KFC is like a business model that has been franchised in different locations, over 200 stores. Now, the owner did not actually like, I'm giving you this. I no longer want the right. I don't have the right to commercialize it again. No, but actually, he grants the franchise like the right to use the particular brand identity, the brand logo, the brand name, and the secret recipes to run the business to be exactly the same in standard and quality that the customers can say, okay, yeah, this is actually like the KFC I bought from this place. Now, if we notice about something about franchising, if the company or the brand will always be the same no matter where you find them. This is because they had made known to the franchisee the know-how, the steps on how to go on about it. That is these procedures, the system on how to run that particular business in that new location. Now, the franchisee pays fees or royalties in return for using the brand identity, the operating method, the system, the know-how on how to run the business. They pay the royalties to the actual owner for allowing them or granting them the right to run the business in a new location. So IP franchising maintains brand standard and quality. Now, this is what I mean by you find out that when a product has been franchised, it tends to be the same in standard and quality. This is because they regulate or make known to the new owner, the new franchisee, the steps on how to run the business. Sorry for that. Example of IP franchising is McDonald's. McDonald's is like the global fast food giant with franchise outlets all over the world. They've made known to the interested brand or the interested entity how to run the product, the secret recipe on how to run that particular fast food in the new locations. Now, if you're eating from point A and let's say you travel to point B, you find out that the McDonald's there tastes the same as the McDonald's you find in point A. This is because they have made known to the entity or the new brand the technical know-how of how to run the business, the secret and the trade secret of that particular business. This is what IP franchises allows an individual to do, to make known to another entity how to run the business without actually transferring the rights of the business fully to them. The franchisee gets to use the brand name, the logo, and the operational method. That is like the step by step on how to do it. Step one, do this. Step two, do this. They give the full details on how to run the business to the franchisee, who uses such step to run the business, operationing and functioning in that particular location. So McDonald's commercializing its IP has generated billions in revenue while maintaining quality. The quality tends to be the same. This is because the technical know-how of how to get that particular, let's say the burger, is the same. They pass it down to the new franchisee to know how to run the business in order to retain their customers, retain the quality and standard of the McDonald's brand as a whole. Next slide, sir. Moving on, we're talking of IP exporting. Like exporting, like just as we export our goods from one country to another, intellectual property is a business in the sense that you can actually commercialize that particular product, that particular invention internationally. Let's say you publish a book in Nigeria on the topic how to study effectively, and you want the book to be available in the USA, in China. Now, this is possible through what is known as IP exporting, whereby you make the product available in international markets via licensing, franchising, or even sale of that particular product. Now, intellectual property, for you to export that particular product to another country, you must register that particular product before exporting, registering an IP such as the patent, the trademark, the copyright, depending on the kind of product you want to put out there in the international market. Export, before you can export your product internationally, that is from your local country to an international country, you must first of all carefully plan, make a market research, and comply with the laws of that new market, because the new market might have the law key. If you want to like sell a product in this international market, you must follow this standard. This is how the market runs. This is the step that every seller or every distributor must follow. So you must comply with the laid down rules and regulations and have your pricing and after sale support. Another ways of exporting your intellectual property can be via licensing, franchising, joint venture, or even assignments. IP exporting can take place in different routes. It depends on how you want to get your products out there in the international market. An example of an IP that has been exported internationally is the Flutterwave, which is the fintech payment solution system that has been exported to over 33 African countries and globally. Now, this exporting has earned that particular fintech company did over 32 billion transaction in 2023, and that company is valued for $3 billion in 2022, as 2022 estimated. Another IP that has been exported is Paystack. This is a very well-known payment system in Nigeria. I have made use of this Paystack for online payments. So now this fintech company has been able to be used in different companies via IP exporting in countries such as South Africa, Ghana, Nigeria, Kenya, and it was acquired by Stripe, another payment system, for 200 million in 2020. So IP exposure simply means putting your intellectual property, the creation of your mind in terms of your brand, your business in international markets, where it's not just being in your home country, where if a product is made in Nigeria, it can be found in international markets like the USA, China, due to the reason of IP exploiting that be made available for IP owners to exploit or commercially exploit their creation internationally. Next slide, sir. Okay, so in conclusion, I'll be talking on the importance of intellectual property for businesses. So now business is IP for business is very important because this is the strategic asset of the business. Intellectual property, in the sense of the patent, the trademark, the copyright, protects that innovation, that creation of your mind. It creates the brand identity, protecting it, allowing you to make use of it while stopping another person from commercializing that particular invention without authorization or permission being granted. Now, registration is something that is very crucial for legal protection to be made available to you as an IP owner. IP protection cannot fully be given to you if you have not been registered with the law of your jurisdiction or even internationally, because the law tends to recognize something that has been made known to it. So registering your intellectual property makes the law to recognize that such a thing exists, and it gives you the right to make money with it, earn revenue, license it, have a competitive advantage over other companies, as when that particular brand or identity has been made known. For example, Coca-Cola, they tend to the law tries to protect that particular brand so that someone else or a new startup will not try to pass off the commercial aspect of Coca-Cola in the name of business, thereby such as deceiving or uh, confusing customers into believing that such a product is coming from Coca-Cola, when in fact it is not coming from Coca-Cola. So registering your trademark, your patent, like it gives you a legal protection. Now, businesses can monetize their IP through licensing, franchising, exporting, assignments, through assignments. There are different methods you can make money as an IP owner. So, Nigerian companies such as Flutterwave, Marvel Record, Biggins has shown that IP's potential to generate revenue globally and locally. So, particular something that was conceived of the mind, that is the intellect. It's the creation of your intellect can make you money locally and globally, so long as it has the legal protection, it has the registration recognized by law, or that it is something unique created by a particular entity, not something copied of or something that has been made known or rampant with the society, because IP always tends to protect something in a tangible form that is new, unique, and not something copied. Or even if it has to be copied, it's something copied, or the functionality of that particular product has to be different from the one already known to the entire public. There needs to be something unique about that product that will make the law to say, okay, this deserves to be recognized, this deserves to be protected because it is new, it is unique, and a strong IP strategy equals to a stronger brand identity, a plus a business growth, international opportunities. Your IP strategy, the way you strategize your IP, can determine if you can make use of your product, if you can commercialize your creation, your innovation, or if it can actually die down being used without you making money, as we've seen where a particular IP has failed to be protected by law due to the reason of not being protected by the law. So if you strategize your IP, protecting it, having it recognized by law, and with over time, such a particular IP has been made known to the public, it has a very strong commercial value, something that investors from locally and globally would want to invest in, you making money from it through means of licensing, franchising. So when you've created a particular product, a particular invention, you can make money in the future without actually investing your capitals through your licensing, your franchising, and so on. I think that is all for the presentation of Group 1. Thank you so much, sir. So sorry for the background noises.
All right, thank you. You can mute your speaker. Thank you so much for your presentation. Well done to you for putting it together alongside your team members. Well done to the members of Group 1 for that very detailed presentation. So I am trying to see if we've been trying to get the two on board to see if their presentation will be possible. It seems for some reason we don't have any person who will be able to make presentation on behalf of Group 2. So what we will do is we will take feedback from the mentors on behalf of Group 1's presentation, and maybe from what they were able to see within the presentation of Group 2, make comments overall for the mentees to take home. So I will be going back to the top to our mentors list and to the mentors who are available in session and in class to give their feedback and maybe just generally anything they would like to add in regards to the session for today. So we'll be starting with Ms. Amel Fodatala. Thank you so much, Mel, for staying this long to this point. We still want to just hear from you overall, share your thoughts on the presentation, and maybe any other thing you would like us to know in regards to the topic for today, IP for Business.
Okay, thank you very much. I will just emphasize on one point that I think that is also very important to add on the presentation that was already good and excellent. Congratulations to all the mentees. When it comes to intellectual property management, especially, it's very important to keep in mind the why of intellectual property. Most of the time, people think about intellectual property. They are just engaging on it like an administrative action that has to be implemented. It's very important to combine what you are looking for with your business goal. Why do you want to have, for example, a trademark or a patent? When you have this trademark of patent, what are you intending to use how are you intending to use it into the market so that it can be profitable? Because we have all the options that was present, like licensing, franchising, etc. But you have to check long-term objectives in order to see if the different options that you are taking now will serve your objective tomorrow. And the aspect of risk management is something also that we have to keep in mind. Intellectual property is something that you use to always present to prevent risk into the market. A few days ago, I read a publication where a company was not able to do a recordals on time. And due to that, they enter into a litigation case. And at the end of this litigation case that happened something like almost 20 years after the company was built, they were obliged to pay something like $20 million to the adverse party. You have to know that each action that you build today can have a very, very high consequences tomorrow. So always think about the why. Always think if at the stage where you are, it is important for you to review your strategy, because there is no one strategy that can last during the whole life cycle of a business. When your business change, your IP strategy also change, and it's very, very important to keep it in mind. When you have such approach, most of the time, it will be very difficult for you to fall, because either you have a new partnership, your question should be, which aspect of intellectual property should I have to manage now? Am I obliged to review my IP portfolio? Am I obliged to review the different agreements that I have? Am I obliged to write a new agreement with somebody else? It's very important to keep all this in mind so that you can face, you can anticipate, I will say, any type of situation, but also you can avoid irreversible consequences. So this is the small contribution that I can add according to this presentation. Thank you very much.
All right, thank you so much, Mrs. Amel, for that very wonderful and detailed feedback. We really appreciate your shared thoughts in today's class. Thank you so much. I trust you'll be available for the question and answer session, so that in case if any mentee has any questions, we can direct it to both you and the other mentors on call. Thank you very much, ma'am. I don't know if Mr. Emmanuel is still on call. Please, I would also want to get feedback from you, if that will be possible. Mr. Emmanuel, are you with us? Okay. If Mr. Emmanuel is not available, we'll be heading over to Mr. Sand. Mr. Sand, if you're with us, we also want to get to hear from you. We'll share your feedback on the mentee's presentation, and also maybe any other thing you would like to add in regards to this class.
Okay, so I was speaking. I didn't know that I was muted. Thank you very much, Amele Fuda Tala. Your perspective of reviewing of IP strategy is on point, because and it's important that they learn this early as they move in their journey. Maybe I think I can even turn my video on a bit, just maybe I turn it off so that if okay, can everybody see me? So
Yes.
Okay, fantastic. Well done. So listen to that presentation, even though there was noise at the background, which we understand that is uniqueness of Africa. We understand the apology is well understood and accepted. You did very well. You did very well in the area of not just speaking about the theory perspective, you're also bringing in the practical perspective. That means you did some work and mentioning the practical tools that we use, from FlutterWave to the other organizations that you did mention, and as well as the franchise strategies. Like this is like what you presented is like a checklist that any to-be business owner should be aware of. And when they do A, B, C, D, E, F, first of all lay the foundation by bringing the theory components of IP and giving us the definition, which in my opening remark, I felt, does it really matter? But when you then went in and so when it mattered now, because it gave clarity. So someone going into something, we have a clear understanding of what they want to go into. First of all, understand that everything is built on theory. And you also created that atmosphere of saying that many African innovators, creators, move the most important, moving ideas to a valuable content, and some ideas become struggle. They can't scale because they are not applying intellectual property, which I feel is very important. And the other aspect of a franchise that you brought in, that means that you can create a system, right? Everyone can create a system that can be translated into a workable model. So it's like methodology. If you apply this and you follow this step, you get the reward. And I appreciate that. So, but I think one of the key takeaways from your presentation is that innovation alone is not enough, idea alone is not enough, and which my other mentor has mentioned, if you start it, you have to watch it, so you reinvent it and see how it moves. So it's not enough for you to just have trademark. It's not enough for you to just register patent. So you have to go with it high. If you reinvent something, maybe you can add one layer of more patent or copyright, one new design that you bring out. You have to just keep an eye on that. The strategy you have today will not be enough for you tomorrow. I think that is what the bottom line is, that and you have to put a system in place where you manage and protect and strategically commercialize these ideas. So it's not more of legal formality, but it's to have it as a strategic asset, which the mentees mentioned. He said IP is, and Max also mentioned, and I think Emmanuel also mentioned, IP is a strategy in a strategy. You get it, right? Because it determines whether the business will survive, whether it will grow, whether it will disappear tomorrow. That is the truth. Your IP will determine that. Because when you start, and one of the things that you observe in the business community, especially in the African context, not just Nigeria, is that business owners, as they grow, they keep on changing. And so, for example, your logo is on the left hand today. Tomorrow is on the right hand side. Tomorrow is orange. Because again, one will not blame businesses, because the capacity to have maybe a designer that will help you maintain this strategic objective you have with IP is difficult, because as a great business, you might not have the resources to be able to see someone maintain your color type and your positioning. And even lawyers are also very expensive. But what you can do is that with those resources you have, you can insist. It can be difficult, I must say, but you think about the future of your business, that if you, in this journey, if you're not consistent, you might not be able to scale. So if you're not consistent, someone might take over your idea. If you're not consistent, so you negotiate with your designers, you negotiate with lawyers that will support you, and you also keep documentation about this, about your brand name, about your brand color, about your trade secret. You keep it there to your eye, because at the long run, it becomes your source of growth. Because without it, you will definitely struggle with it, because there is no way on earth for your business to be a globally competitive company, or for you to convert your idea to a more commercialized, to scale your idea to be commercializing valuable to you, without you maintaining that idea. You have to prioritize it, and prioritizing is also maintaining, as I said earlier on, IP is transformational, and your presentation showcase that. And at the end of the day, I would say congratulations to you, that you have come this far. I believe with your group, one or two things will come out of it. This is your first session. Before we come to, I think it's I don't know how many weeks again that people will have to go through this. You will definitely be better off for this, and you're one of those who will be converting to push on IP, to realize an IP, and as well as to advise people and to take the message of IP to the marketplace, where it will become a serious area that serious area where people will pay more attention on, unlike currently what you have now. Congratulations and well done. You've done very well. Thank you.
Thank you so much, Mr. Sand, for your wonderful feedback. I'm sure the mentees are taking note of everything that has been said. We'll be taking the last feedback from Mr. Max from there. Thank you so much, sir, Mr. Max, for staying till this time. Please, we'd just like to get a little feedback to the presentation from you, and then we would head over to questions. So, mentees, if you have a question while Mr. Max is talking, please prepare your question so that when you want to ask, you can just easily raise your hand, and we'll take your questions. Questions are very important, so please, I want to encourage you to ask questions to get the best in that sense out of the mentors, because I'm sure that there are other areas of IP that are well grasped that they may not have been able to address because of the limited time. So your questions will be able to trigger them to share more. So please let's get ready to ask questions. So, Mr. Max, over to you. We just want to hear quickly a little feedback from you in regards to the presentation and maybe any other thoughts that you may have on the topic for today, that is IP for business. Thank you so much, sir, for being here.
Okay, thank you, Dennis. And let me commend both teams. And let me also apologize. Unfortunately, I missed the good chunk of the presentation by both teams, but I had the privilege of previewing the slides prepared by both teams, and I wanted to really commend you, noting particularly that this is your first session and you're already digging in this much. I particularly liked, I think it was group, let me just confirm, group, I think this is group, is it 1? I think, let me just confirm, yeah. So yeah, so group 1, yes, I particularly liked your slides. I thought, the design, the look and feel of your slides, I thought it was really good. It showed you a lot of preparation into putting the slides together, and I commend you for that. I also love the fact that you tried as much as possible within your slides to do live case studies. You mentioned, a lot of very trendy IP issues, Sabinus. I think I saw, also where you tried to look at the, missed opportunities, correct IP strategy and missed opportunities, Coca-Cola and then Sabinus. And then I think the other one I found very interesting was the success of Qualcomm. Yeah, so I thought that was, was good. Qualcomm and Douglas Engelbart, the people who invented the computer mouse, or at least some of the key technology behind the computer mouse, but failed to properly secure proper patenting right for that, and therefore lost what would have been a massive business opportunity. And then, of course, the Qualcomm story, 4G and 5G technologies is also very instructive because it opens us up to another part of IP, what we call FRAND licensing. So FRAND licensing is a type of mandatory licensing for IP products that form part of technology standards. So, I mean, it's a technical area. I won't want to go into it too much, but like a lot of the technologies behind 4G and 5G, even though there's a company who actually developed them and who is the holder of the patent in those areas, based on the fact that those technologies have formed technical standards that everybody who needs to play in that space, who is providing technology products that run on the back of the 4G or 5G technology, need to be allowed to use it. So governments have what we call a FRAND license, which is sort of a compulsory licensing scheme. So FRAND just simply means that the license is given on a fair, reasonable, and a non-discriminatory basis. So any other technology player in the field will automatically be licensed to use that patent, even though it belongs to Qualcomm or any other player in the space. But in return, the government will also mediate a negotiated fee that will be paid to the owners of the patent in return. So that just shows you the uniqueness of IP and how IP intersects with public policy, because the governments know that simply giving IP or patent rights, for instance, can create problems, because if you give patent to one organization for something that should form a technology standard, it means that other manufacturers of technology equipment cannot use that standard. So to avoid that situation, compulsory licensing will need to come in, which is an element of public policy. So this just shows us how robust IP can be, and IP is not just simply about creating a monopoly for specific organizations. So, but overall, I commend Group 1. Yeah, Group 2, I like the fact that I also saw your slides had live picture samples and all of that as well. I think it's good. I mean, I'm always full of commendation for people in this program, because when I look back to when I was in the formative stages of my own professional career, I knew nothing about IP. I never had this kind of platform, to help me come into the mainstream of the IP. So I'm really happy when I see young professionals, coming to this program to learn more about IP. So all I'm doing is just to encourage you to keep it up. Please follow through all the classes. Ensure that you do not leave the preparation of your group work every week to just one or few people. Everybody participate, because in that participating, you would also get to learn a lot. So thank you all, and I look forward to your questions.
All right, thank you so much, Mr. Max Ikombe, for sharing your thoughts and also the feedback you gave. You were very, very high thanks to the mentees. So, mentees, please collect your flowers. Mr. Max has given them to you. All right, so thank you to our mentors for sharing your feedback with us. We really, really do appreciate, and we hope that those participating on the call are taking note of everything that has been said. You know, what I have noticed within this session is that, you know, we are not just defining things from a standpoint of just theories, where we are highlighting definitions and just sticking to definitions, but we are seeing real-world applications of this concept, of the concept of IP, right? And the way businesses use them to take advantage, to gain advantage over their competitors, right? So, you know, within this line, right, I would want to encourage you to ask questions. You know, some things were mentioned about IP franchising, and I know franchising is something that, you know, can be very tricky. You know, so if you have questions, please go ahead and ask your questions. You can do so by the raise of hands, right? And then I'll call you to ask your questions, or you can send your questions into the chat box and I'll read them out to the mentors for them to answer. All right, so I can see a hand up. Let me get, that is Ozo Koli. Sorry if I murdered your name. My sincere apologies, but you can go ahead and use and ask your question.
Thank you very much. Good evening, everyone. I want to first of all thank the organizer for this beautiful opportunity and to learn. I mean, it is really interesting learning about IP and its application. I also want to thank the members of Group 1. The presenter was very brilliant, and the members who helped to put the group work into one piece. It is not easy. I really want to show my appreciation. So my question is concerning, there was a mention of patent law or something like that. Patent, yes, that gives exclusive rights to the creator of a particular thing. So I want to ask, in the context of an industry, let's say Coca-Cola, yes, or let's use another company, a normal company. So in the course of day-to-day job of Mr. A, if he happens to create something and then due to one reason or the other, there was a problem between him and the company and they went their separate ways. My question is, who then has the right over the property? Is it the company or the individual? Thank you very much.
Thank you for your question. So I think I want to direct this question firstly to Mrs. Amel, right? Amel, please now, can you help answer that question? And then maybe any other mentor that may want to throw in more light in regards to that, then, you know, we can also have your contributions. But Ms. Amel, if you're with us, please, and if you got the question, we want to hear your thoughts on it.
My line was breaking, so I don't know if you can rephrase. I didn't get the question well up to the end. My line was breaking.
All right, so I think basically his question was if in the instance where somebody comes up with an invention while working for a company and for some reason they got to part ways, who retains the rights of the invention? I think that was the summary of his question.
Okay, so if I understand well, he wants to know when somebody works for a company, who owns IP rights, right?
Yes, yes.
Yes, it depends. Let's repose that it depends. I work in OAPE region. According to our laws, the right bear to the company, normally. But normally means that you have an agreement with the employee. And we know that most of the time, people hire people to work for them, but they don't have agreement. So if you have agreement, now you are sure that most of the thing that has been done during the collaboration, yes, to the company. But my advice as a strategist, I will always advise to add this specific information, because if you hire somebody maybe to work on software, and maybe there are some complementary tasks that this person has to do that are not really focused on the main activity, but you took time to mention it through the agreement, it will be more easy for you to ensure that the right should bear to the company. But if you go far from the software, let's say, mission, now this person can claim something. In other jurisdictions, they will say that it depends on the circumstances. It depends if the employee use all the resources of the company to run the innovation or not. So I cannot give a fixed answer to this question because each situation can have different feedback depending on the laws, depending on how the relationship between the employee and the employee, the employer and the employee was established, depending on what the employee used to run the innovation. So that is, in substance, what I can say regarding this question. But concerning Cameroon, when you have an employee, most of the time, as the law specific say that if that person was hired to do something specific into your company, means that you have an agreement with him, all what has been created here to the company directly. But I will add maybe one supplement point is to consider when you work with an employee on a project that has a very big value, that we have a very big value for the company, in order to anticipate that this employee should claim that maybe what you paid was not enough. You have to consider to give him a supplement amount at the end of the project before starting selling it. Thank you.
All right, thank you so much, Mark, for helping us treat that question. I think I saw someone's hand up, but then the hand got taken down. Okay, please, you can go ahead and ask your question. That is Adebi, right? Please go ahead and ask your question.
Yes, good evening. Sorry, am I audible?
Yes, you can
Yes.
hear you loud and clear.
So my question borders on copyright. I don't have yes. So basically, according to the little knowledge I have, in Nigeria currently, as long as a creative work is put into writing, it automatically receives copyright protection, right? But in the case with IP exporting, like maybe for example, a Nigerian product now, maybe he wants to expand his product in another country, probably the US, for example. Now, is there still a need to register for copyright, and how does conventions come into place? Because there are some conventions, particularly the Berne Convention, in which Nigeria and other African countries are a signatory to. So my question is that are these conventions binding in relation to copyright, or is there still need for further registration?
All right, thank you for your question. Mr. Max, if you are with us and if you had the question, please can you help tackle that question, sir?
Okay, thank you very much, Dennis, and thank you, Adejoke, for that question. I believe your question actually is it's a thorny issue that have confronted our courts severally, which is the issue. You are right, first and foremost, that the principle is that with copyright, registration is not a prerequisite for protection. So it means that with copyright, once the work in question has been produced and fixed in a medium, automatically protection ensues immediately. So it means the moment, if it's a novel, the moment you have written and published that novel, you don't have to do a registration with any government office before your copyright is protected. So if you have published your novel and somebody immediately goes to make photocopies of that novel and begins to sell them on the street, you have a right immediately without registration to proceed to sue the person for copyright violation. So it's important to have that basics in place, and largely all over the world, that is how copyright works. In some parts of the world, while registration is not a condition for protection, however, they may have some formalities. So in the US, for instance, there's a deposit you need to make and all of that. In Nigeria, we also have a voluntary deposit scheme run by the Nigerian Copyright Commission. So that voluntary deposit scheme is not what gives you protection, but it can serve as evidence of your production of that copyright work. However, in practice, because our judges always get it wrong, our judges have held repeatedly. In fact, sometime last year, I was at the Federal High Court and the judge was still repeating the same error of saying somebody brought a copyright claim and asking, where is your certificate of registration from the Nigerian Copyright Commission? So it's quite unfortunate. A few of the judges know better now, but sometimes we advise clients just to avoid problems. Even though registration is not a prerequisite, please do that voluntary deposit, have the evidence. If nothing else, it serves to show when you produce the work. It can be an authoritative way to show, if two of us are arguing about who, whether I infringed or not. The fact that I can show that I did a voluntary deposit in 2020 and you can only show that you published the work in 2023, that my certificate of deposit in 2020 would serve as a very strong evidence to show that I produced that work since 2020. So that's for the basics. But the more advanced level of your question now, which is how to protect copyright, internationally. That means, and just correct me if I'm not getting right, Joke, but what you're saying is, for instance, somebody produces a movie in the US and he finds somebody in Nigeria infringing on that movie. Does he need to register in Nigeria, or can he immediately come to Nigeria and enforce his copyright? Am I clear on that, Adejoke? Is that your question?
Yes,
okay,
sir.
Thank you. Yeah, so that question actually is a hot button issue. Now, there was an earlier case called the case of Microsoft versus Franike Ventures. Of course, we all know Microsoft. So there was a company called Franike Ventures that was duplicating Microsoft software in the, this was much earlier, I think in the late 90s or in the early 2000s. They were duplicating Microsoft software such as Microsoft Office, Microsoft Word, and the other Office suites, and selling them, pirating them essentially. So Microsoft took up a case against them. Unfortunately, Microsoft lost that case because though the Berne Convention, like you rightly pointed out, Adejoke, is binding on Nigeria and the US, but the court was of the opinion that Microsoft did not prove that Nigeria had ratified and done a proper documentation to show that US copyright is automatically enforceable in Nigeria. Because of that, Microsoft lost that case. They went all the way to the Court of Appeal and they still lost the case. A few other cases still continue that problem. There's been a recent decision of the Court of Appeal, I think was delivered late 2023 or early 2024, that has tried to clarify the issue. Now, under the Nigerian Copyright Act, there was a regulation issued then by the minister that listed some of the countries that were also members of the Berne Convention whose works also enjoy automatic protection in Nigeria. So part of what you must do when you are a foreigner coming to enforce your copyright in Nigeria is to ensure you go and get a copy of that regulation, ensuring that your own home country where your copyright was originally originated actually is in that list. And that is when that reciprocal enforcement will be recognized by the Nigerian courts. However, you could also prove that, look, your country is a signatory to the Berne Convention, like Nigeria is signatory to the Berne Convention, and produce the necessary instruments of ratification, which usually will be gazettes, showing that both countries are members of that. But it's still a question that a lot of us who are in the IP space are not happy about the way our courts have handled it. The Copyright Act 2022 has also helped to clarify a lot of that misconception. So our hope going forward is that foreigners will no longer have, because it's really bad on our international reputation to have a situation where foreigners cannot enforce their right, whereas Nigerians enjoy the same reciprocal protection in their own countries as well. So we're hopeful that under the Copyright Act 2022, all of that uncertainty about the enforcement of foreign copyrights in Nigeria has been taken away completely, and that there's more clarity as to which foreign countries are entitled to enjoy that reciprocal enforcement. So thank you again for that question. It's a very important question. And of course, people like Mr. San, who are the ones helping us with setting up policy in Nigeria. They do a lot of work in the policy space. It's also a policy issue, and it's something we hope that, someone like Adejoke can take it up and write an article about it. I'll try to supply some of the materials, the recent court judgment, is in writing articles exposing these issues. Hopefully our judges will read them and see how dangerous it is for us to continue to give judgments that downplay our reciprocal treaty obligations, which is not at all a good thing for a nation seeking foreign investment and hoping to also enjoy the protection, abroad as well. So thank you again, Adejoke, for that wonderful question.
All right, thank you so much, Mr. Max, for helping us that question. Mrs. Amel, I noticed that you were trying to say something. Please, ma'am, the floor is yours if you have anything to add to that.
No, I didn't want to add something. Thank you.
Oh, okay. So, Ephraim, please go ahead and ask your question.
Sorry, I think let me just add to what Max was. I think Nigeria has now it's two different things. Either we have signed up or ratified. One thing about Nigeria is that so many things are happening behind the scene. You might not even know until you approach it. So the Benin Convention, I think Nigeria has ratified this. I was checking online and saying in 2023. In 1993, and they updated in the Copyright Commission law of 2022, Copyright Act of 2022. So not too sure. I think it's something that we have to dig a little bit more to just see what is implicated, because it's one thing for Nigeria to sign up, it's another thing for them to ratify. But I know that, with the former minister, there was this call for Nigeria to start ratifying some of these multilateral agreement that we have been benefiting from, domestic, and ratifying and domesticating it. But not too sure. But I think it's something that we have to poke more to see if Nigeria has domesticated it. But what I'm seeing is that Nigeria has joined, but has it been domesticated fully under the Copyright Act? Not sure about that, but it's something I won't have to explore. Thank you.
All right, thank you so much, Mr. San. Ephraim, please, if you can go ahead, ask your question, and then we'll take the final question from Joy.
Okay, thank you very much. I'm in Malawi, and we are just an hour ahead of you, and I see most of you are in Nigeria. I just want to get a clarity about copyright, because I saw from the beginning there was somewhere like software falls under copyright. And I know we have some experts in this field, IP. There are some people that are saying software also falls under patent law based on their functionality. So I don't have a legal background, but of course I'm doing my master's in law, commercial law. So I just want to get a clarity from the experts, from our mentors here. Software, why does it fall under patent? Because primarily it's a copyright. So just want to get a clarity on that one. Thank you.
All right, thank you so much, Ephraim, for your question. I want to leave this question as an open question to the mentors. Whoever can address the question. Okay, I can see Mr. Max. Please, sir, you can go ahead, sir.
Thank you, Dennis. I'll say a few things. I suspect Amel will also give some more insight. Thank you, Ephraim. I'm always happy when I see non-lawyers also joining IP, because truly IP is not for lawyers. IP is really for everyone, and it is when we approach IP that we, particularly in Africa, we are going to enjoy the benefits that IP has. Like one of the common examples I give people is that a lot of the African countries, we are dependent on minerals. So in Nigeria, for instance, we depend on crude oil. But I tell people there's a practical example. Data we see from the year 2023 shows that France made more revenue from the sale of champagne than Nigeria made from the sale of crude oil. And of course, I'm sure you are still going to get to that module where we'll talk about geographical indications. You'll understand that the reason why France is making so much money from champagne is an IP, a type of intellectual property called geographical indications that allows them protect that word champagne. So it means you cannot create a brand of sparkly wine and just sell it under the brand or brand it champagne or write the word champagne on it without belonging to the cooperatives in a particular region of France that produce the sparkly bubbly wine called champagne. So it just tells you how Africa is losing out so much because we have not really made IP a part of our everyday business. Of course, people like Mr. San is also not a lawyer, but doing a lot of work because he's in the commercial space and showing how IP is done. So I'm just saying, Ephraim, I thank you for joining this session, and I believe it will be very useful to you. So now to your question. It's also another very important question, and it's a question that still, I think, in many parts of Africa, we have not answered it well, and it's causing us a lot of loss. So, like you rightly said, ordinarily, we have 6 categories of works that can be protected as copyright. So among them, of course, we have literary works, which is written works. So software in itself falls within that category. But we need to understand software. Software is not just one thing. Software can have several faces or several ways it is applied, and it depends on how it is applied. So software in its purest form is simply codes written, or let me just call them instructions, written by a programmer that directs a computer's hardware on how to perform a particular task. So you can see that in that sense, it is an expression of the creativity of the software engineer. So it means you can bring 5 software engineers, and 5 of them will, in their own unique way, write a software code to implement the same activity, but they'll write it in different ways. So let me just try to break it down a little bit more. For instance, I mean, of course, when we talk about software, we'll talk about the algorithm. So algorithm is just an ordered protocol that tells a computer how to go about solving a particular problem. So let me use something very basic. For instance, lock the door, for instance. So if I want to write an algorithm or a set of instructions on how to lock the door, I can write it this way. Number 1, get up from your chair. Number 2, walk to the door. Number 3, turn the handle, rotate the handle of the door anti-clockwise 90 degrees. Number 4, pull the door towards you. Number 5, release the handle of the door. Number 6, push the door gently to confirm it is latched. And then number 7, rotate the key clockwise 180 degrees to lock the door. So you can see that that's a set of instructions on how to lock a door. But another person could come and write that in a different way. But at the end of the day, we are all achieving the same purpose. So that set of instructions is what we call an algorithm. And typically, that is what a computer programmer does when he writes software. So in that sense, the person writing the software is essentially expressing his creative way of solving a particular problem. So that algorithm, as written, is just like writing a novel. Of course, the language written is not in English language. It is written in computer code. And computer code or computer language, we have different languages. So for instance, one person can write the software in Python language. Somebody else writes it in C++, or there are many different computer languages. Just the way in English language, you can write a novel in English, or write a novel in French, or write in Portuguese. So you can see how the similarity between the work of a software programmer is to an artist who is writing a novel. So in that sense, software is protected as copyright. However, the software sometimes can also be a unique implementation step that controls how the computer performs a function. So in that sense, it is not about the creativity of the software anymore. It's about the function that the software performs. So if what you are trying to protect is that I have a unique way, I have gotten software to perform a unique computer solution, then you can see that that is no longer talking about the expression of how you wrote the software. That's not talking about something useful, a solution to a technical problem. And that is what patent law is all about. So if you can show that your software or the parts of your software are not just about the expression of how to solve, or the expression of how to achieve a particular computer objective, but that it is about the functionality of the computer, then at that point, you can protect it as a patent. So the distinction can be quite, difficult to make sometimes. And even in many African countries, for instance, in Nigeria, we still have that argument where you go to the patent office to try to patent a computer implemented software or invention, and you'll be told that no, you have to go to the Copyright Commission. We always make that argument to them, and there's a distinction between what copyright protects, which is about simply the expression, not the ultimate function. But if you are talking about the function, and if that function is unique, that means it is novel, it is new. Nobody else has used software before. For instance, if my software, for instance, using less ink than invention, that is no longer talking about the way it is performing something new, something novel, and something that can be applied in industry. So in that context, I can get a patent for it. In foreign jurisdictions, what they have done to demarcate that line of distinction and ensure that you can also patent software is to create a category, what they call computer implemented inventions. So if you can show that your software qualifies as a computer implemented invention, then you can also get protection for patent. But like I say, the way you should always look at it is we are looking at expression versus functionality. So if what you are protecting is the way you expressed your software code, that is copyright protection. But if what you're trying to protect is the function that software brings, and that function is unique enough, it is new, then you can protect it as a patent. So always think about it as function versus expression. That is what tells, and the same software can actually have both protection. So I could write a software code that the language I use to write it tells the computer how to implement a way to print using less ink. At the same time, I get a copyright for the way I wrote it, but I can also get a patent for the invention, the unique way it interacts with the computer, with the printer, with the toner, to make sure it uses less ink to print. So you can see that it's the same product I'm selling, but one part of it is protected by copyright, the other part is protected by patent. So it means if somebody else goes to write his own code in a different language or in a different way, but he's trying to achieve the same objective of reducing ink usage in printing, using my same idea, then I can go after him, not in copyright, but in patent, and say you have infringed on my patent. Even though you use a different language, you do not infringe on my copyright, but the function you are aiming at infringes on the function I created. Therefore, you have infringed on my patent. So I hope this tries to explain the difference. It's a very complex area. It's an area where, like I said, even a lot of the African patent registries have not exactly gotten clarity about it. So it's also one of the areas that I would encourage that there should be more scholarship. We should write more and explain the distinction between copyright protection for software and patent protection for software. So thanks again, Ephraim. Good to meet you as well. Thank you.
All right. Thank you so much, Mr. Max, for a very detailed explanation. We'll be taking our final question. We've at least gone a little bit beyond our time. All right. So Joy, you'll be the last. We'll be taking your question last for today's class. So Joy, please go ahead and ask your question. Hello, Joy, please, you can go ahead and ask your question. Joy, can you hear me? Hello, Joy. Okay. All right, Joy, if you cannot, okay, I've seen you dropped your hand. All right, so with that, we've come to the end of today's session. Okay, before we go, sorry, I forgot. We'll be taking pictures right now, right? So please, if you have lighting in your background, kindly turn your video on so that we can take a quick picture while we call it a wrap on today's class. Thank you so much, Miss Amel. All right, so I've done that. Thank you to everyone who was able to turn on their video. For the mentees, please do not forget to share what you have learned on your different social media platforms. Do not forget to share what you've learned on different social media platforms. Do not forget to fill in the attendance and also to reach out to try and connect with the mentors that took you in today's class. I'm sure that they are going to be happy to have you reach out to them if you can. Okay. Also, Koli, please, you can go ahead. I can see your hands up.
Okay, sorry, excuse me, sir. This mentioned attendance. This how are we going to be doing it? This is my first class.
Okay, no problem. We'll send an attendance list after the class, like a link to fill the attendance. So yes, you will fill it through that platform. Yeah. Mary, I can see your hands up, please. What's your question?
Sorry, my phone got disconnected when you said you wanted to take picture.
Oh, okay. That's fine. We can take a picture with you in frame, right? So you can go ahead and turn on your video. We'll quickly take a picture and add it to what we have already. All right. Thank you, Mary. Thank you also, Mr. Ephraim. All right, so we are done with that. So for my end, good night, everyone. See you in class next week. Also look out, the tags for the next week will be posted in your group, I think before tomorrow morning, right? So please let's make sure to be all on board. We are all sharpening ourselves and we are becoming better in our learning experience and in our learning exposure. All right, so see you all next week. Thank you once again to our mentors who have stayed to the very, very end. We are very, very happy to have you with us. You make us better. You help our knowledge of IP, and we will do well to share this gospel of IP. Good night, everyone, and enjoy the rest of your evening.
Good evening. Thank you. And congratulations to all of you.